This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about what happens when you reject UIM coverage at the time you apply for insurance, and that when it's rejected in writing, nobody gets that coverage because it's not there. Karina Monasterio appealed the district court's judgment in favor of Progressive Express Insurance Company on Progressive's complaint for declaratory judgment and Monasterio's counterclaim against Progressive and in favor of Rasier-DC, LLC and Uber Technologies on her counterclaim against those defendants. In Progressive Express versus Karina Monasterio, Uber Technologies, and Rasier-DC, the United States Court of Appeal for the 11th Circuit on November 18, 2024, affirmed the United States District Court's ruling. Progressive sued for declaratory judgment to clarify its rights, duties, and obligations under Florida's Transportation Network Company, TNC, Act regarding uninsured motorist coverage. Progressive sought a declaration that Florida law did not require it to provide uninsured motorist coverage for a car crash that occurred while Monasterio was engaged in a prearranged ride as an Uber partner driver under contract with Rasier-DC. Monasterio counterclaimed, seeking a declaration that Florida's TNC Act required Progressive, Rasier-DC, and Uber to provide uninsured motorist coverage for her accident. Florida's TNC Act required insurance coverage may be maintained by the TNC driver, or the TNC vehicle owner, or it may be provided by a combination of their policies. Among other requirements, the insurance must provide uninsured and underinsured vehicle coverage as required by the statute. The auto insurance policy issued by Progressive to Rasier-DC did not provide uninsured motorist coverage for it or its TNC drivers. It provided bodily injury and property damage liability coverage, comprehensive and collision coverage, and limited medical payments. It covered TNC drivers under contract with Rasier-DC if the driver was operating an insured auto, which included, quote, any auto being used by TNC driver providing a prearranged service using the rideshare application, access with the driver's valid credentials. Florida statutes provide that no motor vehicle liability insurance policy which provides bodily injury liability coverage shall be covered and delivered or issued for delivery in Florida with respect to any specifically insured or identified motor vehicle, registered or principally garaged in the state, unless uninsured motor vehicle coverage is provided therein or supplemental thereto. The statute clarifies, however, that the requirements for uninsured motorists do not apply to any policy which does not provide primary liability insurance that includes coverage for liabilities arising from the maintenance, operation, or use of a specifically insured motor vehicle. For policies that do not provide liability coverage for any specifically insured motor vehicle, the insurer must make uninsured motorist coverage available as part of the application for insurance. The coverage required under the statute is not applicable when, or to the extent that, an insured named in the policy makes a written rejection of the coverage on behalf of all insureds under the policy. Neither Rasier-DC nor any other named insured paid the premium for uninsured motorist coverage. To the contrary, an authorized representative of Rasier-DC signed a written statement explicitly rejecting all such coverage. Based on the evidence submitted, the district court entered summary judgment in favor of Progressive, Rasier-DC, and Uber on Monasterio's counterclaim and crossclaim. The 11th Circuit concluded that the statutory text was clear. Florida's TNC Act requires TNC drivers engaged in a prearranged ride to have uninsured motorist coverage as required by the Uninsured Vehicle Coverage Statute. Because the statute did not require uninsured motorist coverage for the auto insurance policy covering Monasterio as a TNC driver, the TNC Act did not require the coverage either. The policy was not issued for any, quote, specifically insured or identified motor vehicle, close quote, registered or garaged in Florida. So the requirements of the statute did not apply, and uninsured motorist coverage was not required because Rasier-DC made a written rejection of the coverage on behalf of all insureds under the policy. Because the statute did not require uninsured motorist coverage for the auto insurance policy, the TNC Act did not require Progressive, Rasier-DC, or Uber to provide that coverage to Monasterio. In my opinion, it is always important for a court to read the language of the applicable statute and the policy to determine coverage on an automobile insurance policy. Here, the TNC statute was complied with by Rasier-DC because it rejected the UIM coverage, and coverage was clearly not required by the statute. The only question I have is why the parties thought it was worth their time and effort to appeal this dispute to the 11th Circuit. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,900 blog postings. You can also subscribe to these videos on rumble.com and youtube.com. They're also free. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog so that they too can subscribe to the blog and or the videos on Rumble and YouTube. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.